So most videos probably have titles like how to be home by 30, how to buy a home, not be scared, step-by-step stuff like that. I don't think there are a whole lot of videos telling you how to lose a home. And why am I doing this? That's because it's a thing in law I want you to be aware of. I'm Dionne Jackson Miller. Thank you so much for joining me courtside. It's time for tea. So this story is from a decision of the Jamaican Supreme Court handed down in March 2025. It's about Roy DeSado and Jennifer Brown. They met in 1988. They were in an intimate relationship. They had a child together. They bought a house in 1999. But Mr. DeSado had an affair with another woman, so they separated in July 2002 and he left the property. Now, they had two different stories, well, kind of different stories about what happened. Mr. DeSado told the court that they had both got a mortgage from the National Housing Trust and they were both making mortgage payments. He said he started renovating the property in or about October 2000 and the house was finished after that. Now, he said after he left the property in July, in October 2002, Miss Brown changed the locks and prevented him from entering the property. Despite that, he said he continued to maintain the property. He said he had the house painted, he had the yard cleaned, and he paid the mortgage. He said he made another attempt to enter the property in November 2019 and January 2020, but he was unable to do so. Miss Brown now had a different story. She said Mr. DeSado didn't make any mortgage payments after he left and that he didn't contribute to any expenses of the household. She said he didn't pay any property tax and he didn't spend any money maintaining or keeping up the property. Miss Brown said she maintained the property by herself. She said she repaired the roof, she put in kitchen cupboards, she finished a bathroom that was unfinished. She put in an electronic arm on the gate, she improved the driveway, she painted the house and she paid the mortgage. She showed the court several documents, such as those proving that she had paid the mortgage from July 2002 to September 2022. She also showed her property tax receipts, and that's about 20 years of property tax receipts as well. She also took out a home improvement loan with a credit union in June 2000. She serviced the loan from money in her account until it was paid off, and she had a letter from the company. Now, their daughter also gave evidence. The daughter said her father left the property with his furniture and his personal belongings in 2002. She said he would randomly visit during that year, but because of the quarrels between himself and the mother, Miss Brown changed the locks in or about early 2003. She said although her father tried to enter the property around that time, he wasn't able to do so and he has not returned since. Now, her evidence supported her mother's evidence. She said it's her mother alone who had maintained the property since the father left. She's now a doctor and she's been helping her mother with the household expenses since July 2015. She said her father has made no contribution to either the household or her own expenses since he left. Mr. DeSado didn't reply to either affidavit from Miss Brown or from the daughter. He didn't show the court any proof that he had paid the mortgage. So one issue that the court had to decide was whether Mr. DeSado and Miss Brown were spouses and whether the house was a family home. And that's because there's a law called the Property Rights of Spouses Act that says how a family home is to be treated. Under Jamaican law, it's not just people who are legally married who are regarded as spouses, because you have common law marriage that's recognized in law in Jamaica. And the law says a spouse includes a single woman who has lived with a single man as if she were in law his wife, and that has to be for a period of not less than 5 years. Or a single man who has lived with a single woman as if he were in law her husband for at least 5 years. Now, Mr. DeSado was saying they were spouses. Miss Brown was saying, no, we weren't. And since they weren't married in law, the court had to look at the evidence to see whether or not their relationship would have been regarded as a common law relationship. And what the judge said is that there wasn't any evidence, first of all, whether they had been single at the time, because under the law, you have to be dealing with a single man and a single woman. So if you're married, for instance, and then you go and live with somebody else, no matter for how many years, that relationship will never be regarded as a common law relationship because you're married. You can't have two wives, you can't have two husbands. And the court looks at a number of factors in deciding whether or not this is a common law relationship. For instance, whether the two people are living together in the same house, whether they're sharing their daily life, the stability and the permanence in the relationship, how they handle their finances, whether they have a sexual relationship, whether they have children, what's their intention and motivation, and what would be the opinion of a reasonable person looking at the relationship. And the court said that in this case, the only evidence before the court was that they lived together from 1994 to 2002, that they had a child together and they bought property together. The judge said the evidence is stark. It does not disclose a reasonable basis to find that they were living together as if they were husband and wife. In other words, Mr. Desado is saying they were spouses, but he didn't give any evidence or enough evidence to the court for the judge to be able to come to that conclusion since they weren't legally married. And of course, when I'm saying they're not legally married, I'm talking about, they didn't go through a ceremony, they don't have a marriage certificate to say they were married in the eyes of the law. So since the court couldn't say they were man and wife, then the family home argument doesn't hold up. So the other question now is whether Miss Brown had dispossessed or taken away Mr. Desado's rights in the property. And this can happen under the law because the law says that after 12 years of someone not asserting their right to a piece of property, somebody else can claim it if that other person has been treating it as if it's their property. And that is how squatters, for instance, are able to acquire rights in a particular piece of property if they've been living on it for 12 years. And of course, it's not just a living for 12 years. You have to be asserting your rights. You have to be in open occupation and control of the property. There had to have been no other attempts to get you off the property in the meantime, factors like that. So since Mr. Desado left the property in July 2002, he had 12 years from that date to assert his rights. But he didn't go to court until October 2020. That's 18 years later. So the time period is not in his favor. But also, what happened during those first 12 years, Miss Brown had to convince the court that she had been in possession of the property to the exclusion of Mr. Desado. And the court, in making its decision, looked at a Privy Council ruling from 2003 called Wills and Wills. And that was a major ruling when it came down, major way in which the law was going to be regarded as to property ownership. In that case, Mr. and Mrs. Wills had owned two properties together as joint tenants. Now, Mrs. Wills left Jamaica, she went abroad, and when she would come to Jamaica to visit, she wouldn't go to the property, she didn't have any of her possessions there. Mr. Wills and his second wife lived in one of the properties and they rented out the other one, they collected the rent, and all of this was to her exclusion. She wasn't involved in any of that. Now, when Mr. Wills died, the first Mrs. Wills now says she had come for her property. Because she's like, all right, man dead, I'm my own now. And the court said no. The court said she had lost her rights in the property because she basically had abandoned it for over 12 years. So back to Mr. Desado and Miss Brown. The court said since Mr. Desado left the property in July 2002, he hadn't paid any property taxes. He didn't paint the house. The judge did not believe Mr. Desado that he had sent people to maintain the yard after Miss Brown locked him out. And the judge said it was clear that it was Miss Brown who had been paying the mortgage. So the judge found that Miss Brown had been in exclusive physical possession of the property since Mr. Desado had been locked out in July 2002 and that she had met that 12-year period needed under the law to assert her rights, her sole rights now in the property. The judge said, I find that by locking him out, Miss Brown has satisfied the court that she intended to treat with the property as her own. She has made significant repairs to the house, paid the mortgage and property taxes without the input or agreement of Mr. Desado. Most importantly, she has prevented Mr. Desado from having access to the property. In this case, her acts were in fact hostile to Mr. Desado, and her decisions regarding the property clearly demonstrate that her intention was to exercise control over the property for her own benefit. In contrast, Mr. DeSado has accepted that he made no efforts to recover his title to the property until he filed a claim in court 18 years after leaving the property. So the judge was satisfied on the evidence that Miss Brown had dispossessed, taken away Mr. DeSado's interest in the property. In other words, she's now the sole owner in-law of the property. So the moral of the story, folks, if you walk away and you leave your house just so, you don't exercise any control over it, you don't spend any money on it, the person living in it, depending on the circumstances, may be able to acquire the property. Not talking about a situation where a person is paying rent, because the act of paying rent shows that you are there by permission. Each case is going to be decided on its own facts, so please check a lawyer if you think you might be in a similar situation, or if you think you have anything to be worried about. The lawyer can advise you how you go about asserting control or asserting your claim in the property. The lawyer can advise you how you should go about ensuring that you do continue to assert your property rights. I want to add that a whole heap of people get killed or injured over land, right? You don't want that to be you or anybody associated with you. If you're involved in a breakup, and we know how nasty those can get, and there's property involved, and you're the one who is moving out, make sure you get legal advice to ensure that you don't end up losing your property. Because we don't want you visiting the property because you say, okay, you're asserting your rights, and anything happen and you're going to have violence or anything like that. That's not what we want. I want you to be aware of your rights, but to exercise your rights in a way that maintains the peace. This may involve going to court. You do have situations where one person in a relationship that has gone sour, and sometimes both people are being unreasonable. Sometimes you need a court involvement. There are circumstances, for instance, in which the court can make a court order that the property should be sold so everybody can get their money and go about their business. Your lawyer will advise you what's best for you in your particular situation. But you hear I'm telling you, talk to your lawyer. Don't try and take matters into your own hands. We don't want that. So I'm going to leave it there. Thank you so much for joining me courtside. I'm Dionne. I'll see you next time. Remember, please like the video. Share it with somebody you think might be interested. Of course, subscribe to the channel if you haven't done that yet, and click that notification bell so you know anytime I drop a new video. Alright, going back to my tea.